This is a review of abatement from my Wills, Trusts, and Estates class. Abatement occurs when an estate does not have enough funds to meet all its gifting obligations. You'll typically find this where there is such large medical, funeral, legal, tax, or other bills that hit the estate and greatly reduce its assets. Now, when this occurs, the normal solution is to create a hierarchy among those gifts. And as you look at those gifts, certain gifts will become abated, that means reduced or terminated, based on where they fall within that hierarchy. The general hierarchy will look something like this. You'll have the residuary gifts be touched first, then the general gifts, and last the specific gifts. The reason specific gifts fall last is that there's a presumption that the testator believed them to be the most important gifts under the estate plan. This goes along the lines of the gifts are so important to the testator that he or she actually specified what gift is going to whom. And the way this looks is a mink coat to X, a Cadillac to Y. It's going to be a very specific gift. Where a general gift can be something like $10,000, which can be paid out of anything in the estate. The estate parts can be sold to fund that gift. And the residuary gift, that's, if you recall, is going to be that bucket at the end where anything that was not a specific or general gift will get thrown into, and that will pass to whoever is named as the beneficiary of that gift. Now, California has a hierarchy that's much like that. The first amount of property to get hit would be those that are not disposed at all by any instrument. Then you've got the residuary gifts, and this is where California gets interesting. With regard to the general and the specific gifts, the first group to be touched are those gifts to non-relatives of the transferor. So if you're the transferor's best friend and you're the person the transferor spent most of their time with, but the transfer happens to have a relative who is also listed as getting a general gift, you're out of luck if the estate's out of money because you're going to lose your gift before that relative's going to lose their gift. And the same is true for the specific gifts. They look at non-relatives first, and the last one standing would be the relatives. Now, some jurisdictions have allowed intent to affect this hierarchy. They'll still have a hierarchy by statute, but they'll give a court discretion to look into the actual affairs and the intent of the testator to determine if that hierarchy makes sense. For example, it's possible the testator gave the residuary estate to his wife and other gifts to lesser individuals in his life. The idea being that there was just a few things he wanted to go to these people, but the main part of the estate, the real money, the real value, he wanted to go to his spouse. Now, if that situation occurs, if he can show this was the intent, then that residuary clause can move from the first gift to be hit or abated to become the last. And that's an approach that the UPC follows and some states follow. It's out there. You could always argue it most places. Doesn't mean you're going to prevail, but it is a scheme that is out there in a minority of states.